May it please the Court, my name is Bill Rogner. I represent the employer carrier in this case. I'd like to reserve 3 minutes of my time for rebuttal. Your Honors, the facts of this case were, quite frankly, all over the place. We do know that the claimant had some chronic pre-existing problems and a history of falls. There was a lot of confusion and a lot of conflicting evidence, however, with regard to the condition of the threshold at the doorway where the claimant fell. In fact, the JCC was unable to reconcile that conflicting evidence. The essential problem with this case, the central problem with this case, is that the JCC resolved the conflicts in the evidence by applying a non-existent presumption of compensability. This order has 3 dominant and sequential paragraphs. They control the case. They are paragraphs 7, 8, and 9 of the merits order. In paragraph 7, the judge addressed the conflicting evidence with regard to this threshold where the claimant fell. And here's exactly what the judge said. A great deal of attention was focused by the parties on the state of repair of the transition or threshold at the instant of the fall. But in the end, there's no competent substantial evidence, one way or the other, to say what role this threshold played in her fall. He went on to say the claimant doesn't even know why she fell. So then he goes on to paragraph 8. In paragraph 8, he asks a question. Well, what do we do when neither version of the facts is convincing to me? And he says, well, what we do is we apply this Dubriel presumption of compensability. And here's what the judge said. The rule of law in a situation such as this, where a conflict exists as to exactly what happened, is that if the injury occurred at work, then it's compensable. And that, of course, is flat wrong. Then he goes on to paragraph number 9. He wraps it all up and says, well, unconvinced in 7, apply the presumption in 8, claimant wins. Now, they would have you focus solely on the language in paragraph 9, where the judge throws in all the, I accept the claimant's version of the case, blah, blah, blah. But paragraph 9 can only be read in conjunction with paragraphs 7 and 8, because the judge applied a logical, sequential, although incorrect, analysis in order to reach the conclusion regarding compensability. 7, I'm unconvinced. 8, there's a presumption. 9, claimant wins. Now, the case should have been over when the judge said, I'm unconvinced by either party's version of the case. Because the law is not, if you fall down at work, it's a compensable workers' compensation claim. There must be some occupational causation. And that has been engrafted in the statute in 1990 and in 1994 with the adoption of the major contributing cause standard and the changes to the definition of arising out of, which requires something more than I simply fell down. There must be some work-related risk or hazard that contributes to the injury. And that is true even without the existence of a pre-existing condition, which we had in this case. And I would rely on the Hack case primarily in establishing what I've just told you. But if we move on to the idiopathic condition, well, from a medical standpoint, only 2 doctors testified that could provide opinion testimony in this case. Their IME doctor, Dr. Baker, he never examined the lower extremities. He had no opinion whatsoever with regard to her chronic pre-existing problems. The other doctor that testified was our IME doctor, Dr. Evans. And Dr. Evans did examine the lower extremity, and he did provide opinions with regard to this lady's pre-existing chronic arthritis, chronic swelling of the legs, and diabetic neuropathy. Dr. Evans said there was no doubt that these conditions could cause that fall. And that's consistent with what the claimant told Dr. Girbala almost immediately after the accident. She told Dr. Girbala, the history that Dr. Girbala had was that the claimant fell after her knee gave out due to arthritis. So this was an idiopathic fall, but what does that mean? What does it mean? We talk about idiopathic a lot, but what does idiopathic mean? Well, idiopathic means any disease or injury that is of uncertain or unknown origin. Uncertain or unknown origin. Well, that's exactly what the judge said happened here in paragraph 7. The judge said, well, there's all this conflicting testimony about why she fell. And she says this threshold was bent up and she tripped over the threshold and fell down, although she admits she doesn't really remember. And there were lay witnesses that said either the transition strip was fully repaired and flat or it was bent up and maybe that's why she fell. And he said, there's no CSE either way to figure out which version of the story is correct.
Mr. Rogner, that definition you just gave for idiopathic is certainly a definition that a medical doctor would give. I don't think there's much question about that. But is that how that term has really been used in the decision law?
Well, I thought you might ask me that, Judge Allen.
I've always wondered myself.
Well, you know, I was sitting there preparing for my oral argument, and I thought to myself, well, I know what idiopathic means. And sometimes when you write a brief, you sort of assume that people know what you're saying. And I went back and looked at the briefs, and nobody really talked about that definition.
I don't think any of the cases ever
Well,
define it.
actually they do.
Oh, really? Okay.
But, I'm hesitant to even tell you the names of the cases because they're not in the briefs, and it's not really fair. But I found them last night. And
some of them were written by Earl Zemer.
That, you know, Judge, I didn't check to see which judge wrote it, but I can give you two citations if you want them. Okay. Metropolitan Dade County versus Russell. And that's 637 Southern 2nd 69, 637 Southern 2nd 69, and Hillsborough County School Board versus Williams, which is 565 Southern 2nd 852. And that quote that I got, that I just gave you,
that came from one of those cases?
Came straight out of those cases. Well, it came out of the earlier case, the Metropolitan Dade County case, and then was cited with favor in the...
I get the impression, though, in reading some of these cases, that when they use idiopathic, what they really mean is something unique to the claimant, as opposed to something of unknown origin. And where you're nodding, you must be sort of agreeing with that impression.
I do. I agree that it's both. I agree that if I am standing here and I simply collapse for no reason, that's an idiopathic fall. It's a fall without known reason. Now, what happens?
But isn't that irrelevant for determination of the case? Isn't the determination of the case whether there's CSE to support a determination that this injury arose out of the course of the employment?
I don't think so, Judge. And the reason I don't think that that's accurate, and of course, my first issue in the brief, I assert that it's a de novo review, and the reason is because the judge applied a presumption. But here's what the judge said in two separate paragraphs, 7 and 9. Okay? In 7, the judge says there's no CSE one way or the other to say what role this threshold played in her fall. And then after 8, which is where he applies this presumption, in 9 he says, I conclude that the claimant's injury occurred as a result of her foot catching as she passed over an area of undisputed disrepair involving the threshold. How can you say both?
Could you repeat that, please?
I conclude that the claimant's injury, which occurred as a result of her foot catching as she passed over an area of undisputed disrepair involving the threshold.
So he concluded that she fell on a disrepaired threshold.
Yeah. Except in 7, he said, I can't say one way or the other whether it was in disrepair. So, look, it has to be read sequentially. It's the only way you can get there. It's the only way it makes sense. Okay? So you've got to look at 7, where he says, EC says it was this way. It was perfect. Nothing wrong with it. Claimant says it was a mess. She tripped over it. Okay? But I can't say which way it is. And so then he goes on, the very next sentence in paragraph 8 is, the rule of law in a situation such as this, where a conflict exists as to exactly what happened, is that it's work-related.
So you disagree with your opposing counsel's side of Scully, I believe it is, or the earlier case from the Florida Supreme Court where they ruled in favor of the employer carrier, and the claimant says the same rationale applies here, it just leads to a different result.
No, if what the judge would have said, if the judge would have said the following, and again, this doesn't even get us to issue 2, which is the idiopathic issue, but if the judge would have said, okay, I considered these witnesses and I considered these witnesses, I accept these, I reject these, and I find as a matter of fact that the threshold was in disrepair and that's why the claimant tripped and fell.
But didn't he really find that in paragraph 9?
I thought that's what they said in paragraph 9. It said,
I agree,
there's
Judge.
conflicting testimony. It said, but I accept the testimony of the claimant and resolve all conflicts in her favor. I conclude that the claimant's injury, which occurred as a result of her foot catching as she passed over an area of undisputed disrepair involving a threshold doorway.
Yes, I agree, he said that. You've got to cut out paragraphs 7 and 8 in order to make that make any sense at all. Because
But, I mean, isn't it just an inartfully drawn order?
Well, I'm not going to disagree with that. But Judge, it's not, this judge, look, you throw that stuff in paragraph 9. I write these orders all the time. And you always write I've considered all the evidence and, accepted all the evidence that I believed and rejected all the inferences.
The lawyer for the claimant wrote this order and didn't do a very good job.
Honestly, Judge, I didn't try this case.
You didn't try, so you don't know which one wrote it.
I don't know who wrote it. I know the defense didn't write it, but because I know the defense lawyer, and he wouldn't have written this in a million years. And I honestly don't know if the judge wrote it himself or if the claimant's lawyer wrote it. But my point is this: if you look at the judge's intellectual gymnastics as he goes through this order, he says, "I'm not convinced, so I'm applying a presumption."
Excuse me for interrupting. You're saying he can't get to paragraph 9 without driving through the presumption.
That's exactly right. I'm saying the presumption got him to 9. And then the lawyer or the judge, whoever was writing this, remembered all the please don't reverse me stuff that you throw in these orders about I've resolved all the conflicts and I picked the claimant's version of the case. Okay? But the judge did not get there until he said, I'm unconvinced by either party. I don't believe either side. I'm not convinced. So what do we do in a case like this? What do we do when I can't figure it out? Well, we apply a presumption. And the way he got this presumption was he looked at this horn book written by a non-lawyer. When my lawyers, young lawyers that work for me, come and they got this book in their hand, I get upset because they shouldn't be relying on this book. I don't think the judge should have relied on this book either, because what this book says is exactly what the judge said in his order, and it's wrong. It was right. If this lady had been hurt in 1986, it was right. She wasn't hurt in 1986. She was hurt in 2006. And what happened was all those cases that were in this Debreel horn book transposed into this order were based on a version of the statute that mandated the following. In any proceeding for the enforcement of a claim for compensation under this chapter, it shall be presumed that the claim comes within the provisions of this chapter. Now, Judge Barfield, I know you've been hearing these cases long enough to remember those days when the Supreme Court told us that the law was to be liberally construed in favor of finding compensability for the claimant. That's what the Supreme Court said. That was overruled legislatively in 1990 with 440.015. And we had, until 1990, this presumption that required us to assume that these things were compensable, which is exactly what the judge did here. And my central point is that 9 doesn't remedy 7 and 8. And I see I'm running out of time, so I'll say what little I have left.
Good morning. I'm Wendy LaQuasto, Fox and LaQuasto. I'm here representing the appellee claimant today, Pamela Owens. I think it's fairly obvious when you read the briefs that this case involves a fundamental dispute about what the JCC ruled. And that dispute is based upon the fact that the EC has simply refused to accept the fact that the JCC rejected its defense that Ms. Owens fell because her foot caught on this damage threshold. And that's clearly stated in paragraph 9 of the final order. That's what he said. She fell because her foot caught on this damage threshold. That means it's not an idiopathic fall. That means something at her workplace, at her employer's premises, caused her to fall. So all that stuff about idiopathic falls, special hazards, increased risk doesn't apply because this isn't one of those.
What about the paragraph 7 where he says there's no CSC to support what he turns around and says in paragraph 9?
There's I laid out all the evidence from the deposition about what everybody said about this threshold. I sent you a picture, which you can't even see, but there were some people that said there were layers of tape that made the threshold raise up higher than the floor. There were people who said the tape was curled up so that tackiness was exposed. There were people who said it wasn't curled up. There was people who said it was 18 inches.
With all due respect, I understand that. I think you're making the point that there certainly was a lot of evidence on both sides of the equation. But don't we have to say that paragraph 7 doesn't exist to rule in your favor, where the judge says there's not enough evidence to show one way or the other? It's a tie. And the tie, according to your opposing counsel, goes to the employer carrier because your client had the burden of proof.
No, I don't believe that you need to read paragraph 7 that way. I think you need to read paragraph 7 as saying there was a lot of evidence out there, and in the end, I'm not sure whether she caught on sticky tape or if she caught on a raised up threshold or if she caught on, a loose threshold. The bottom line is she caught her foot on this disrepaired, is that a word? Not repaired threshold, and that's what caused it. And it doesn't really matter whether it was sticky tape or raised up or, by the guy's wheelchair or whatever. It was not in a good state of repair.
But I assume, as far as you're concerned, you have no objection should we choose to ignore paragraph 7 and 8.
Well, I think that number 9 says it, and that's the ultimate finding that the JCC has to put in his order under the statutes. He has to make an ultimate finding of fact, and it's there. And he says she fell because her foot caught on this threshold. I agree with you. It's not the most artfully drawn order. But I disagree that he applied a presumption. If you look at, my position as maintained in the brief is a simple CSE case once you get to the fact that it's not an idiopathic fall. And under the premises rule, because she was going into work and she was injured at her employer's premises, she's arising out of in the course of her employment. That's number 1. And under Vigliotti, the second element that she had to prove was major contributing cause, and that's Dr. Baker. He says the fall on February 06 is a major contributing cause of her broken and injured shoulder. So I got number 1 under the premises rule because she tripped and fell on this threshold on her employer's premises, and I got number 2, major contributing cause. Now, they say that there's no major contributing cause, and they point to Dr. Evans, but Dr. Evans never made an opinion. He was never even asked about major contributing cause. Yeah, he gave a diagnosis, 6 different kinds of conditions, and they asked him in his deposition, well, would it be possible for any of those other conditions to have caused her to fall? And he said, well, certainly it's possible. Anything's possible. But when he came back, he said, I understand she fell. She fell. That's what caused her. She tripped, and that's why she fell. That's what he said. And when they specifically asked him, well, are you saying that any of those 6 other things that you mentioned in your diagnosis caused the accident? He goes, I don't know that. I'm not saying that. Well, are you saying she fell because of edema? No, I'm not saying that. You saying she fell because of neuropathy? No. He's not saying that any of those other conditions were the reason that she fell. It's not idiopathic, it's not personal, it's not a pre-existing condition. He's saying she fell because she tripped on the threshold. And that's the only other evidence that's out there that's medical. And so since Dr. Baker is the only one who provided evidence on major contributing cause, and he said the fall is the major contributing cause of the shoulder injury, that's major contributing cause. Good golly, I couldn't imagine that I would sit down now, so I'm not going, I have a few more things that I just wanted to say, I guess, in response. On the Dubrell thing, I attached that in my, on the excerpt, I attached that in my answer brief. I think what he's saying there, he's not Larson. I'll say that first. But I think what he's saying there in those paragraphs is he's reciting the premises rule. And, the premises rule, Vigliotti says it. Vigliotti lays out the analysis that you would apply in this case. And the premises rule says that
can we get back to the 2 paragraphs? I hope you don't mind.
I guess that I want to talk about what you want to talk about.
Well, in paragraph 7, the judge said, there's no competent substantial evidence, and I don't want to endlessly discuss this, but no competent evidence to say one way or the other, what role that play. And by that, he's referring to the exact state of repair of the transition strip. Now, I think in paragraph 9, what he seems to be saying is, and I think you make a compelling argument there, that he's rejecting any notion that it was an idiopathic condition. He's rejecting the employer's arguments that it was her legs, that she was at fault, essentially. And so, therefore, he comes to this conclusion that, therefore, it must have been the threshold. So you have two diametrically opposed findings of fact, it seems possibly to me, in this order. Is that not a fair description of those two paragraphs?
There was, that's what the EC would like you to say, and I'll point out that they haven't said that they haven't argued that the order is so internally inconsistent that it precludes review. They haven't argued that. I submit to you that there was evidence that this threshold was higher. It went from carpeting to tile, I think, was what the majority of people said on the other side. And there was evidence from one of the witnesses who said that that little threshold part that went over where the two kinds of flooring surfaces met was higher, raised up. Okay? I guess if you want to say, you could read paragraph 7 as saying that there wasn't any damage at all. It was just a raised up threshold. You know, sometimes we walk over areas and they have big ones, and that's what caused her to trip.
Well, I'm not trying to say anything with all due respect. I'm not trying to make a factual finding. I'm trying to find out what you think that sentence, what is the legal effect of that sentence in this case?
I think that the ultimate finding is in paragraph 9. And I think that that's what Chavarria told us that we all needed to look for in comp orders is the ultimate finding. And that's what the JCC needed to do, and that's what he said in paragraph 9. Like I said, I don't think it's the greatest order. I'm, not happy to have to defend an order that's written like this. I'll be the first one to say that. But, I think that this paragraph can be read as saying that it was a raised threshold and that's what caused her to fall, and that if you read it that way, it's not there's no internal inconsistency. Now, I think the majority of the evidence showed that there was.
Would it be possible to extend another theory that they had some testimony about it was in a state of disrepair and then later it was repaired? And whether it was in disrepair or repaired at the time, he can't tell. But she testified she tripped on something. It could be raised. It could be repaired and raised. I've got a real problem with the inartfulness of that order, but the rest of that paragraph 7 appears to recite the claimant's testimony, which is accepted, that whether it was in a state of repair or disrepair, she tripped on it.
Oftentimes, that's what these orders do, is they contain bukus of facts that are really just a recitation of what the parties are saying. And, paragraph 7, as you're pointing out, is a recitation of what claimant says. Paragraph 8 is, as that's what I pointed out in my brief, it's really just a recitation about the EC's defense. I mean, their in closing argument, their whole defense was there's no major contributing cause because this woman had an idiopathic fall. And that's what their defense is. And so didn't arise out of because it's a pre-existing personal condition, and that's what paragraph 8 goes to. 7 to claimant, 8 to 7 goes to claimant's testimony, 8 goes to the employer's carrier's defense, and 9 goes to the ultimate findings that the JCC made. That's what I argued in my brief.
Excuse me, at the conclusion of paragraph 7, in reference to the previous question from the bench, the judge notes that the argument that it could have been her fault is rejected and says that, as such, it cannot be considered as a contradiction of the factual explanation of the accident provided by the claimant. That would seem to buttress paragraph 9.
Right, exactly. And the use of the word presumption in there, although it's also, there's a couple unfortunate things in here. Unfortunate at the beginning of paragraph 7, reconciled at the end of paragraph 7 and in paragraph 9, and there's the, there's the word of presumption that they use in paragraph 8. That's how he starts it out, but really it's just the premises rule, and what that all is consistent with the premises rule. So I think that the other thing that Mr. Rodner asked you to do that I want to respond to is, his big argument is that the claimant didn't resolve the conflicts in the evidence about the threshold, and we maintain that he did. Paragraph 9, that's the ultimate finding, and he says if you look at the intellectual gymnastics of the JCC, I think it's what he says, by looking at those paragraphs, then this is the only result that you can come to. And I would submit that if you're looking at the intellectual gymnastics of the JCC, that you would be stepping over the bounds of a review in court and becoming a fact finder. So unless you have any other questions, I'm going to maintain there's CSE in the record to support the fact that Ms. Owens' accident arose out of the course of her employment, and that there's a major contributing cause to show that the fall that she sustained in February 2006 caused her shoulder injury, and that the order should be affirmed in its totality. Thank you so much.
Okay, Judge Thomas, you asked a question which I think went straight to the heart of our position here. I don't think you can fairly read 7 and 9 in any way but as being inconsistent with each other.
What do you say to the contention that you didn't argue, though?
That we didn't argue what?
That the order is so internally inconsistent that it's not subject to review.
Well, that's not my point. I don't think it's so. I think that the inconsistency is perfectly resolved by the judge incorrectly. And the way that he resolves the inconsistency is by applying a presumption that does not exist. Look, what if 7, 8, 9, instead of been written in 3 numbered paragraphs, were all written in 7? She says, well, 9 is the ultimate finding. But all these are findings. They're all findings. So what if he had just put 3 paragraphs under number 7, so it's all there in 1 paragraph? Why would that make a difference? It shouldn't make any difference at all. What the judge said was, and Judge Barfield, you asked about this. You said, well, maybe it was just that it was raised and repaired. That's not what he says in 9. What he says in 9 is she tripped over an area of undisputed disrepair, about which he said there's no CSE one way or the other to say what role it played in the fall. The only way that you get from 7 to 9 and have it make any sense at all is to actually read the words he wrote, which are, in a case such as this, where it's unclear as to what happened, we apply a presumption of compensability. That's wrong. That's not, we didn't get our fair shake because he applied a presumption that doesn't exist. We want the judge to be directed to apply the law correctly. And if he's unconvinced, she doesn't win. Claimant doesn't win. Claimant doesn't win a tie. You pointed out, Judge, that I say this is a tie. It's exactly what I say it is. Tie goes to the defense now. Tie used to go to the claimant, and the legislature changed that. Tie doesn't go to the claimant anymore. Tie goes to the defense. And at best, this was a tie. So I don't think that unless you decide to scratch parts of this order out and just read paragraph 9 in isolation, I don't think it's a sustainable order. And we ask you to reverse it. Thanks very much.
Thank you, counsel. That concludes our arguments for the week. Court's adjourned.